So, shall we start?
Two-minute, please. 2 minutes.
Okay, sir.
Yes, please.
Okay, sir. Good afternoon, everyone. I welcome you all to the workshop of ICSI IIP on the topic recent IBC case laws and amendment. Today we have with Mr. Kumar Vishnoi as a faculty for taking session on amendment in CIRP relationship. Let me briefly introduce Mr. Kumar Vishnoi. Sir is a highly qualified professional with a deep understanding of insolvency and bankruptcy law. He is a member of Insolvency and Bankruptcy Board of India and is a Bar Council of Uttar Pradesh. He has also been a member of ICSI IIP, demonstrating of the commitment of continuous learning and professional development. His experience in handling complex cases and interacting with diverse stakeholders makes his valuable resources in the field of insolvency and bankruptcy. I am confident that his experience will provide valuable insight. Sir, you may now start the session.
Thank you, Mr. Dheeraj. So, shall I start now?
Yes, sir.
Good afternoon, everyone. I take this opportunity to thanks ICSI IIP for inviting me for presentation on the recent amendments in the CRP regulations. So I am sharing my screen. Is it visible? Can someone confirm me?
Yes, sir. It is visible.
Yeah. Thank you
Yeah,
so
it's visible. Good afternoon, sir.
Yeah. Very good afternoon, sir. Thank you so much for confirmation. So, as you know, recently the IBBI has amended CRP regulations on 3rd of February 2025. So, this session is dedicated to that amendments only. So, we will be discussing in detail what is the purpose, how, and what is the effect of this amendment. Let us come directly to the first amendment, which has been first, let us see some highlights. What are the amendments IBBI has done in the CRP regulations? So basically, these amendments are in respect of handing over the possession in real estate matters. Another key highlights of the amendments is appointment of the facilitators, participation of the competent authorities. I am just reading the bullet point, what we are discussing today, what we'll be discussing in detail later. So, fourth is the report on real estate development rights and permissions, relaxation for real estate allottees, monitoring committee for implementation of the resolution plan, and MSME registration status. So, these are certain points which will be covered in the recently amendment, which has been effected on 3rd of February this month. So now coming to the item number 1, or you can say the point number 1, handing over the possession. So handing over the possession, a new regulation 4E has been inserted. Before going into the details of the amendments, let me remind you the discussion paper which was published by the IBBI. So I am sharing the discussion paper for the better understanding. First, let us discuss about the discussion paper. So this is the discussion paper which was there on 7th of November 2024. So under this discussion paper, if you can see, certain proposals were outlined by the IBBI. So I am reading the this part only, this selected part. The proposal outlined in this discussion paper over a range of critical areas including. So why I am reading this discussion paper? Because the amendments has the base on this discussion paper. First point in the discussion paper was that proposed inclusion of the land authorities in the Committee of Creditors COC meetings. So this provision, this discussion paper proposal has been effected through this amendment. So we will discuss this point also. Second, handling cancelled land allotment in real estate insolvency cases. This point has not been, I think, considered in this present amendment. It is IBBI has not come out with this proposal as of now through this amendment. Third point, empowers COC to facilitate participation of association of allottees as resolution applicants. So this has been taken care of. Fourth, clarification about inclusion of interest in the home buyers claims in CIRP. So this again has not been included in this present amendment. Representation of large number of creditors through facilitators. So this has been prescribed, this has been enforced through the amendment. We will discuss this. Proposal to disseminate Committee of Creditors COC minutes to the meeting to all creditors in class of real estate projects. So I think it is required to be there, but there is no amendment in this regard also. We will not deal in with this point. And 7, streamlining possession of handover in real estate projects. So this is the 7th number point where the amendments has come. So amendment has come by inserting regulation 4E. So let us first come to the point number 7 directly. What is the proposal and what was the issue at that point of time? Yeah. This one. Is it visible to everyone? Or shall I need to enhance
visible,
this?
it's visible.
Okay. Thank you. So if we go into the details, like because I spoke to many colleagues and asked whether they have gone to the discussion paper or not. So some of them has informed me that they have not gone into the details. So I feel it proper to discuss first this proposal, then only the amendments. So I'm going into the detail of this proposal because without going into this, I think this will not be justified to go into the details of the amendment. So let us start this. So what is the issue? So if you see that the triple IPI, this is the insolvency professionals of ICAI, which were constituted, which was constituted to go into the detail about the uh, problems and difficulties which are being faced into the real estate matter. They have formed the study group and they have given the report. On the basis of that report, the proposal came into place and discussed. So one of the issue was streamlining possession handover in real estate projects. So the issue was the IIPI report on real estate has emphasized the need to implement possession handover proposal from the discussion paper dated November 6, 2023 for providing necessary clarity. In the context of the CRP, IP face the critical task of ensuring business continuity. Yes, we all know that there is a Herculean task of business continuity we all are facing, including the management of the inventory. So in the real estate project, as you all know, the land or the apartment or whatever the asset, that is the inventory. The real estate sector presents a unique challenge where in many cases creditors have fulfilled their contractual obligations and the CD has completed unit constructions, yet the formal handover remains pending. So everyone knows that in the real estate project, we as a LOT or any person who is the purchaser usually complete his part. He has paid the entire amount of his plot, apartment, shops, whatever it is there. But the formal registry in some cases remains pending and the company goes into the CIRP. So in those cases, this is the challenge. Now, further reading, currently the courts, currently what is happening that the person who are aggrieved, who has paid the entire thing and the company is under the CIRP, is not getting the possession, is not getting the registry, then people are going to the courts also and the courts are uh, deciding the matters as per their inherent powers. So let us discuss this also. The IBBI has very well explained here. Currently, the courts have exercised their inherent powers to permit ownership transfer and registration during CIRP in the select project. Honorable NCLAT in Alok Sharma and others versus IP Constructions Private Limited observe that CD is the owner of the commercial space and had accepted that the possession was with the appellants admittedly. So here in this case, possession was with the person who filed the appeal. The appellants are allottees of the commercial space in Karol Browse. Although the CD had handed over the possession of the commercial space to the appellants, admittedly, no sale deed was executed by the CD in favor of the allottees prior to the commencement of this year. The houses so constructed is the business of the real estate company, and the value of sale of those houses will always appear in the credit side of the profit and loss accounts as revenue from operations. Very well. Hence, this is not an asset in case of real estate company as it is recurrent business activity of the company and it is its business for continuation of its operations as a going concern even during this year. So here the NCLAT decided that we are unable to sustain the views of the respondent RP that these houses registration will violate moratorium under section 14 of the code. So what happened in this case? The RP denied the possession holder that no, I'm not going to register your project, your unit, because if I register this project, this unit, then this will be violation of the moratorium because it will be amount to the transfer of the assets of the city. So here the NCLAT viewed otherwise. What further NCLAT said that the registration of all these houses in the is the procedural requirements. In case of real estate company where the appellants are already in possession of these spaces, the rights of home buyers cannot be affected adversely in the corporate insolvency resolution process, and their interest is to be appropriately preserved and protected within the framework of the IBC. So this is what NCLAT held in this matter. Now coming further, in another case, 7.3 point is there in the discussion paper. The Honorable Supreme Court, this is the Supreme Court judgment, in the CIRP of the Hacienda Project Private Limited in Noida versus Lotus 300 Apartment Owner Association, 27 September 2024. This is a very recent judgment. The petitioner Noida must adopt a positive and proactive approach. See what Supreme Court has remarked, that the authority must adopt a proactive approach to ensure that the flat owners, buyers are given possession to their flats and that the registered deeds are executed. So here also the Supreme Court clearly directed that the registration must be executed and the home buyers must not be prejudicially affected. The CFO, the CEO of the Noida shall appoint the nodal officer. Further, the Supreme Court directed that a nodal officer will be appointed to ensure that there is a compliance with the order. The nodal officer will interact with the Lotus 300 Apartment Owners Association as well as the RP of the builder company, which is now under CRP. So the company was under CRP and the nodal officer and the RP was directed by the Supreme Court to ensure that the compliance of the order shall be made. The RP shall sign the documents. So this is important. The RP shall sign the documents on behalf of the builder, company developer. The list of the flat buyers, owners, flat numbers along with the area will also be given by the resolution profession. So these are the two judgments, very relevant judgments, which we must keep in mind while dealing with this amendments. Any one of us want to discuss on these two amendments? If any questions arises, so or otherwise we shall proceed further.
No,
Yeah.
you please continue.
Okay. Right. So further 7.4, this is also very important for the understanding of all of us. See, in real estate cases, as I told you that the immovable property is the inventory of the real estate business, which needs to be sold in order to run the city as a going concern, and the accrual of such revenue is provided in the PL account. So dealing with the same for running of this CD as a going concern is not violation of the moratorium. For the reason, the insolvency professional, while doing so, may impine on the rights of other creditors. A requirement of approval COC has been kept for a balance purpose. So here, what IBBI has done, IBBI has amended this regulations by giving the power to the COC for approval and all. So on that basis, we will discuss later on. So this is the proposal and the issue. So thus, now I am reading this part. Thus, there is a strong case for allowing transfer of immovable property in appropriate cases if the concerned stakeholders, that is creditors, have approved the sale. So where there is an approval of the COC, then RP can transfer the assets. Just hold on, please. Yeah. So thus, where the allottees have been paid the full amount, have paid the full amount and occupied the unit or possession of a plot, apartment or building, the transactions need to be formalized through the transfer of such unit during the resolution process with the approval of the COC. So this is clear-cut proposal or clear-cut resolution in such cases was given by the IBBI. Further, units which are under technical possession of allottees should not be included in the IBC process by the RP. The objective is the resolution of the real estate project. It is smooth handover of units to the rightful home buyers. Thus, to expedite the resolution process and avoid delay during the unnecessary holds up, the allottee can be given the option to take possession of the units as is various basis or on payment of the balance amount, if any, after taking into account the funds required for the completion of the unit after approval of the COC. Once units are handed over, the registration and sublease shall be done. So considering all these problems and study and all, the proposals come. The proposal in this discussion paper was that to facilitate the smooth handover of occupied units or where possession has been transferred to home buyers, it is proposed to allow RP to hand over the ownership of a plot, apartment or building to the allottees through transfer during the CIRP process. RP may also be permitted to hand over the possession of units to the allottees on as is varied basis or on payment of the balance amount, if any, after taking into account the funds due and funds required for completing the units. So this is all regarding the handover of the possession amendments which has come into force now on 3rd of February. So that was the basis why this amendment proposed. Now let us coming to the amendment, then we will discuss on this point in further details. So regulation 4E under the CIRP regulations has been added. This regulation says that after obtaining the approval of the committee with not less than 60% total votes, the resolution professional shall hand over the possession of the plot, apartment or building or any instruments agreed to be transferred under the real estate project and facilitate registration where the allottee has requested for the same and has performed his part under the agreement. Now the floor is open for discussion on this very much debated issue. This has been a issue under most of the real estate matters where the building has been constructed, but the RP was not allowed to transfer or giving the possession or whatever it is. Yes, please. Any?
Yeah. Actually, this issue was discussed into this discussion paper also, as you suggested that there was some discussion committee of the IPA also. I was a part on that, and there was an issue behind this committee discussion at that point of was that RP has to manage the company as a going concern. And
Yes.
when RP has to manage the company as a going concern, he has to even offer the positions also. But as you know, in certain cases, there is no OC, COC, other things are available. And as such, RP cannot hand over the position, cannot be responsible. So I understand that this IBC regulation is pointing about the same. If the COC is agreeing to hand over the position, so RP can hand over in those cases. So they have amended that 50% voting resolution should come in and then do this handover in position.
Yeah, 66% voting total voting.
66% voting, yeah.
Yeah. So, what is your view? You are saying that if there is no OC or CC, the RP can hand over the possession or can execute the registry?
Actually, जहाँ तक as much I know in real estate matter, suppose RP or the existing earlier management has applied for the OC. If they have not given the OC within 2 months, so it is considered as a deemed OC. In those cases also we don't have the OC and we don't give the position. So now I think they are allowing by approval of the COC that if the OC is already been applied and it is not been granted by the authority, but whatever be the reason, so possession may be given.
Okay.
Because here the real sufferer is the home buyer who has paid the money since long and their money, their possession is pending. Now the flats are ready just because of certain compliances. So it should not happen. Because of certain compliances, the issue remain pending. So it should be given to the home buyer.
Okay. So, any other view on this point? Any other learning members'
Yeah,
view?
I think authority people will also be part of the committee, COC or SCC, whatever it may be. So that will be easy facilitation for.
Yeah, I think that is
approvals.
another amendment. That was the discussion paper also. The regulation has come up. I think Shravan sir will let us know about that amendment also.
Yeah, we will discuss the
Yeah.
representation of the authority in the latter part. But so see, there are some cases or there are some CRP where the RP is not allowing the registration of the unit, even though the possession is with the allottees. reason being, the RP is of the view, in some cases, I will not name here, the RP is of the view that there is no OCCC fire. If I transfer the petition, if I execute the registry and later if there is anything happen, who will be responsible? So his view was that, another view, his view was that in cases where OC, CC and everything is complete, only registry is pending, he will go by this regulation amendment. Otherwise, he will not go. So I want to discuss this thing before learned members, whether, so see, there are two cases, there are two scenario. One which I just explained, that the unit where the petition has already been handed over, OC, CC, fire, every norms have been complied, only registry is pending. In that cases, this regulation may be adopted by the RP. But what about the other, which you were, Mr. Sandeep was saying, that in cases where OC, CC and the things are not complied, and it is deemed, once the OC, CC has been applied by the rest well promoters, then it is deemed that this is complied. So in that cases, can the RP hand over the registration even after the approval of the COC? So this is a question which is, I think, still unanswered. What you will say? Then I will tell you my opinion on
My interpretation is that only, suppose, see, normal circumstances, so RP is already doing registration because RP is supposed to maintain the company as a going concern. I think this registration signifies where some pendencies are there. Now the technical compliances are there. As in the real estate cases, it is a provision. Suppose if owner has done his own part of obligation, and it is written that the request has, the RP has this RA has also, sorry, home buyer has also done his part of obligation, and something is pending on the account of authority for not granting. Then within 2 months, if it is not done, so it is considered as deemed. It is written in the OC also. In those scenario, I think we can go to the COC, apprise the COC, take 66% voting, and then do the registration of that project. Otherwise, in normal circumstances, we don't require it. As a company, we have to do the going concern, and we can do the registry also.
You are
अगर
correct.
कुछ होता है नहीं पर ये लोग रजिस्ट्रेशन किया रजिस्ट्रेशन तो will be signed by RP tomorrow if something happens whose neck will be on the block.
That is why I think COC approval is there, 66%.
Mr. Anis, please.
No, so are you saying it is COC's neck on the block or RP's neck on the block?
No, RP is acting on the instruction of COC in that case. And as per the regulation proposed by the IBI, because IBI has said this, suppose if we don't do this, being a RP, then anybody will complain against us in IBI, then RBI will issue why you are not doing it.
In
We
my
are a duty
opinion,
bound when it has come to the regulation also.
in my opinion, there are the three parties, because now we have to distinguish between the position and again position in subclause, which is a absolute position, and one is a position for fit out, what now RPs and other builders are doing. And second one is a NODA authority. I'm talking about the leasehold property, leasehold flats. And third one is the registration authorities. So that means to complete the process, there are the three persons. One is a builder, which is in the hand of, now I can say RP has stepped into the shoes of builder. Second one is the NODA authority or the other authority. Third one is the registration authority. So far as the amendment is concerned or the Supreme Court order is concerned, so far Lotus is concerned, that I do agree, because they have specifically and very particularly directed to the RP and the nodal officer to do the registry and whatever. But Noida authority says, if my dues are pending and if the compliances have not been done, like bylaws, like layout plan, all these things, illegal construction is there. Suppose it is a illegal flat, how can RP can do the registration, or the nodal officer or the Noida authority can say, without granting OC and CC, we can give a go ahead to go for registry. And third one is a registrar. Registrar says, no, you get a you get a NOC or from NODA authority, then thereafter we will do the registry. So now my precise question is that, so far as RP is concerned, irrespective of whatever amendment is concerned. So whether it is in the absolute domain of the RP, irrespective of, again, if COC approves, say I say COC say you go ahead for the registration or you go ahead for the partition, but can RP can do? Is it because end of the day you have to see the project is legally constructed or not constructed. And third one, you see the performed under his part of this agreement. Now we have to understand what is the performance to be discharged or to be performed by the builder, by the home buyer, by the RP. I take an example. In a BBA, builder buyers agreement, there are certain clauses, say maybe 40 clauses. Some clauses may be in the favor of the customer, maybe in the home buyer. Some clauses may be in the favor of the buyer. So what RP says, I am in the shoes of builder. So, there are clauses like this. If construction is delayed, they have to pay the 40 rupees or 50 rupees per square feet per month, like this, like this, like this. Home buyer says, no, I have paid you since 4 years back. And now you pay, so far as this part is concerned, for 4 years, the penalty you have to pay to me. So, no, what will happen? Who will take a decision for that? Because, buyer has performed his obligations. He has performed, he has paid 100% money. Now he is entitled for that. RP says, no, I will not do so far as the amendment is concerned. So there are some of the inconsistencies and misinterpretation or the interpretation, whatever may be. I think this amendment is very, very, to me, it appears to me very confusing. And I don't know how the RP alone, stand alone, can take a decision so far as this matter, so far as the handover matter is concerned. I know 2 or 3 projects in Noida where RP is giving the permission for fit out. He says, you take it, you do whatever I want to do. Whenever we will get a OC or COC, OC or CC, we will get a registration in your favor. But standalone on this basis of this amendment, the RP can take a call or RP can do, it is beyond his control. He cannot do each and everything. At the most, only
But
he
I
can.
think-
So you take a position at your risk. Whenever we will get approval, that the registry will be effective then thereafter.
Very
Sir,
good point.
Sir,
Demonstrated.
situation is this. Let us say NCLT में जाते हैं. Okay, and if there is a dispute on the property, okay, which is okay in where the corporate debtor is the party to the vote. Okay. Now, as part of the resolution plan, will the NCLT approve or adjudicate on the property dispute? No,
No.
because they will say you go to the competent judicial forum and have that adjudicated there. Now, if the municipal authority has certain rules and regulations, after which they will give OCCC, how RP will take a decision which overrides the municipal law or regulation? अब एनसीएलटी खुद नहीं करता है और आरपीओ को करने को बोलते हैं?
So,
सर
sir,
आरपी का भी ये है कि आरपी भी अपनी कन्वीनियंस के हिसाब से ही करता है. Because what's happening, I know a lot of the project, I will not name of this RP, but I know. So what kind of activities they are involved in and what they are doing, because ultimately this is the subject of Noida authority or whatever may be the UPS IDC or any other authority, unless and until they agree, because the absolute title comes for the registration only once OC or CCE gets it. Otherwise, it is a very, very difficult for the RP to go for the registration. How can he convince सब रजिस्ट्रार में से नो तुम कौन होते हो, मेरे पास तो कोई ऑर्डर ही नहीं है, मैं कैसे मान लूं? अगर इंसॉल्वेंसी का अगर इसमें अमेंडमेंट आया है, इट इज फॉर यू एंड फॉर द IBBI और समथिंग लाइक दैट, सो व्हाई हाउ इट इज बाइंडिंग ऑन मी? मैं नहीं करूंगा, मुझे तो OC और CC लेके आइए वहां से. तो इस तरीके की प्रॉब्लम्स जो है ना, वो आरपी के. मैं आपको एक क्रूड एग्जांपल बताता हूं. जो सरफाइसी के अंदर सेल होती है, मतलब उसमें तो IBBI भी इन्वॉल्व नहीं है. जिन प्रोजेक्ट्स के अंदर बैंक सेल करता है और ऑक्शन में इफ आई एम द परचेजर, आई गो फॉर रजिस्ट्रेशन ऑन द बेसिस ऑफ सेल सर्टिफिकेट, जैसे नहीं OCCC नहीं है, आप जाइए पहले OCCC लेके आइए वहां से, UPS IDC से या नोडा अथॉरिटी से, देन देयर आफ्टर वी विल रजिस्टर योर फ्लैट. तो वो तो बाई ऑपरेशन ऑफ लॉ है. DRT से ऑक्शन हो रहा है, उसको भी वो मना कर देते हैं सेल सर्टिफिकेट को रजिस्ट्रेशन करने के लिए. ये तो फिर भी IBBA का केस है. सो टू मी, सो फार एज इन नटशेल, ये अमेंडमेंट में अभी क्लैरिटी आना जरूरी है कि इसमें स्पेसिफिक रोल आरपी क्या प्ले कर सकता है, बिकॉज व्हाट इज विद इन हिज डोमेन एंड व्हाट इज बियॉन्ड हिज डोमेन, अनलेस एंड until it is clarified, so it is not possible. And particularly the definition of the operation has to be given, because it is fit out for operation, absolute operation, or operation for registration.
All right. All right. Very good discussions here going on. So let me further define it, because it's a very important issue which need to be deliberated in detail. So if we go by this amendment only, so let us find out what projects can be covered under this amendment. So let us go by that way. Otherwise, there are problems, I know. But let us have some conclusion. What are the projects which can be, where the registry can be executed or permission can be given by applying this amendment? Yes, please, Dr. Arun Mohan.
Sir, so far as my opinion is concerned,
Yes.
मेरा तो इसमें यह है कि परेशन फॉर फिट आउट, बिकॉज यू गो एंड एंजॉय द, बिकॉज यू आर पेइंग द बैंक इंस्टॉलमेंट, you are paying the interest on that, whatever is there. So this is your property, since you have paid the complete price, entire consideration, so now you are entitled for that. So you can enjoy, we can give you the permission for fit out, so you enjoy till we get a OC or CC. So far as your problem of the financial burden is concerned, so it's get solved. बट सो फार एज द अदर लीगल हर्डल्स आर कंसर्न, कौन उसका रिजोल्यूशन एप्लीकेंट होगा, बिल्डर आएगा नहीं आएगा, टॉयले होगा नहीं होगा, ये सब चीजें अलग है. बट यू गॉट ए परेशन ऑफ योर प्रॉपर्टी. सिर्फ आपका एक रजिस्ट्रेशन नहीं हुआ है, लेकिन आपकी जो दूसरी लाइबिलिटी है वो खत्म हो जाएंगी, इन द सेंस कि आप रेंट पर रहते हैं तो आपको वहां पर रेंट नहीं देना पड़ेगा. दिस इज योर प्रॉपर्टी, एंड ऑफ द डे यू विल गेट इट, इट्स जस्ट ए मैटर ऑफ टाइम. दिस इज टू व्हाट आई अंडरस्टैंड फ्रॉम दिस.
Okay, very well. So let me, break this 4E. After obtaining the approval of the committee with not less than 66% of the total votes, one thing is this: you need to have the approval of the COC by 66% votes here. The resolution proposal shall hand over the possession of the plot, apartment, or building. The word used is shall. Try to convince me. The resolution proportional shall hand over. There is no option on the RP.
But one has to understand the definition of the partition also, because
I'm coming to that, sir. I'm coming to that. Shall hand over the possession of the plot, apartment, or building, or any instruments. What are those instruments?
Instrument is they are talking about like a BBA, like a partition letter.
Yes, means the transfer. Now we will discuss that. Instrument agreed to be transferred under the real estate projects and facilitate registration, where, in what cases, where the allottee has requested for the same and has performed his part under the agreement. Now, let me give an example. Suppose I am the home buyer and my flat is with some builder who has recently gone under the CIRP. I have paid my entire dues. The building has constructed and can be possessed. Can the possession be transferred by the builder if the registration process has not been started? To my view, in those cases, RP can give the possession on as is where is basis based on the discussion paper we have just read out. Is there any problem, sir?
No, so far as is where is, I don't understand. It may be the like a structure only, because when it is not in a living position, or you can enjoy the fruits of that.
See, sir. If suppose I am willing to get the unit on as is where is basis, definitely if there is something which has, because I am seeing that I have paid this 50 lakh rupees or 1 crore rupees, whatever it is, and the unit which I could get, it is value more or less near about that. So I can apply to the RP that, see, I have paid my entire amount and now I am willing to get the possession of the unit, the units in the project, the building is there. Kindly give me the possession as per the regulation 4E recently amended. Take the approval of the COC. If COC approved, then RP is bound to give the possession of the unit This is my view.
Sir, even with due respect, I do have a disagreement so far as this proposition is concerned.
Yes, sir.
That
Very
the,
good.
the, the reason being that because you see in a tower there are 23 floors, and each floor is consisting say 4 5 flats. And on the 12th floor, I am taking a hypothetical example. If on the 12th floor I have a flat, I say कि I'm taking as it is. You know the facilities. Can I enjoy it? Because you know they're the all civil lines, they're the all water pipelines. Unless and until this tower is in a inhabited position, which anyone can enjoy, which everyone can enjoy. You bearing apart from that, whatever whether a legal title comes to me or not, I can compromise on that. But so far as in a living position, I can occupy, I can enjoy. I can say, yeah, I am ready to take it in as it is position. This is
Very
what I
correct.
would like to make a distinction between
yes,
two.
yes, yes. I got your point. So my take is this. There are three requirements. Na? One, I have applied for the allotment or for the possession. Second, I have paid my entire part.
Yes.
So when I have paid, there must be 80 to 90% building completion. What I suppose. Third,
Yeah,
if
yeah.
there is any problem, definitely COC is not going to approve that you give the possession.
That is a
COC will look into
presumption.
everything.
That is a
So
presumption.
yes, so what I'm trying to resolve the issue that in what cases. So in cases where the building is completed, only small things may not be completed, like parking may not be given or club may not be built up, or some very nice small problems or like are pending, which
Yes.
can be executed in with a very small amount of investment, whatever it is. But the possession can be given and the person can live there. So in those cases, there may not be any harm, and we can apply this amendment by empowering the COC and directing the RP to hand over the possession in those cases only. So will that be fine to those cases, or there is
Yeah,
further
no,
change?
no, no, while endorsing your view, I do have an agreement with you, but subject to that, this amendment must say if the building is 90% or 90%, to just have a clarity, because you know it should not happen like this. Say 50% is completed, which is neither here or there. So they must say when a tower or the block or whatever is there is a 90% or 90%, 95% is completed. So then in that case, COC may agree upon and can authorize to give the permission for that. Because for the 5%, maybe the cupboard, maybe the like small things, I do agree. But so far as the 95%, like lift should be there on the 12th floor if someone has to go. It should be in a position like sewer line, like a seepage line, like everything is completed.
Correct,
Yeah.
correct,
So
correct.
this is to what
Agree,
it should be completed like it should be
agree.
amendment should be like this.
So I
90%
can,
provided the
yes,
90% facilities have been completed or the construction activities or amenities to that have been completed.
very clear. So I can take it in the way that where the building can be, where the building in such a position that people can reside there, or they
Yes,
can.
yes, yes,
Uh,
yes,
so in
yes,
that cases, if COC allows, RP should, go by this amendment.
yes,
Yes,
yes, yes.
Sandeep ji, your views? No, I think. So, yes,
Rajesh.
Sandeep. So I have given a very good example, and we have
Yes.
discussed here. So the cases where the building is almost ready for possession, and the LOT has given his part, he's paid entire things and his part, and COC also approves. Then in that cases, RP can hand over the possession on as is where is basis, because why as is where is basis? Because there is no fund in the company to complete all the formality, to complete all the, shortcomings, or you can say the other facilities which are pending.
Yeah, I think whatever the facts are there, we are need to disclose to the COC member.
Yes,
And as somebody was suggesting me right now that how the RP can do the registry is another thing. I think the duty of the RP is already assigned under the IBC to run the company as a going concern and do the registry. That is very much already there. But in certain cases, when the building is ready, because of any OC or something, it is pending. So whatever the fact is there, let us discuss in the COC meeting, and the COC in the commercial wisdom find suitable. Then they will approve it. RP is only authorized when 66% voting is there. Otherwise, RT is not obliged to do that. So RP has a shield of the COC now. Rather earlier this shield was not available. Anybody can go and say that RP is not doing registry. So RP is not doing registry. He has a valid reason. He can discuss it to the COC, and COC says no. Then RP will not do. Otherwise, if everything is okay, RP will mention that. Then RP will do the registry.
Correct.
Otherwise, good suggestion that fit out we can offer. So fit out definitely we can offer. We will not do the registry by that time. We will offer only fit out.
All right. So, okay. So, second question. The building in such a state which we have discussed and COC has allowed. Still, RP can deny because regulation prescribe that RP shall. If COC allows, then it is binding on the RP to get the petition, to execute the petition or to execute the registry as well. Can there be any scenario when the RP deny that no, I'm not going to do this? I think not.
No, there may be again is a hypothetical. Say
Yeah.
it is within the knowledge or from the record. RP finds it is illegal because some of the floors are carrying or the building has been illegally, which is not as per the bylaws, and which
Correct.
may be threat to the which may be the potential threat to the OC or CC in the near future. So he can say he can apprise to COC or he can take a decision. No, this building, so far as the record is concerned, it has been constructed illegally and the flats are illegally built on that. So I cannot give. This
Yes,
is
sir,
what
he
is
is
his
right.
duty.
Suppose if this is the situation, we will apprise to the COC. And I don't think so that any COC will approve the registration when something is illegal. So no COC
No,
will approve that.
even he cannot apply. I am asking only just I am apprehending. If I say I happen to be the RP of a particular project, and I say no, I have a concrete. I know it is from the documents. So this is a illegal flat sale. So it is not my duty only because in case if I put it to COC and again COC is represented by AR, which is holding say 98% or 99% home buyers. So he can get this resolution approved because every home buyer is interested in that. Well, go to hell. Only this is a one flat. Why RP is stucking? So whether first of all it is the duty like resolution plan I'm talking about. So he has to see whether it complies. Although he is not a person, he has to see whether it is fitted in within the all legal framework. Again, the same thing is there. The RP has to see the proposal which I am putting up for handing over the partition, whether this tower or this block or this project is legally constructed. I don't see any problem in near future to get a OC or CC. So he will not put, I think I'm putting a writer, so far as my interpretation is concerned, I'm saying being a RP, I will not put up a COC. It is not my duty to put up any illegal items or any illegal construction proposal to COC. This is my duty. I say no, I will not put it up for the handover position.
Yes, I concur your views. Absolutely fine. Because in cases where the home buyers are 98% shares, no, and suppose AR is represented or directly the home buyers are representing, so RP shall not go into this illegal position or transfer, whatever it is. I'm agree with your views, sir. No issue. So let us come to the another amendment. Is it fine? So next point लेते हैं हम लोग, next amendment. Is it okay? Is it okay?
Ji, please.
Thank you. Good. So now coming to the appointment of the facility. One point I have missed, sir. So let us also discuss. One petition is okay. What about the registry? Suppose I'm giving the example. Suppose a project which is constructed 4 or 5 years back, and the petition has been handed over by the buyer, by the builder. Now the registry is pending since last 4 to 5 years because there is no OC or CC. So in that case, can RP go for the registry after approval of the COC? Because for getting all these OC and CC, there are certain requirements like construction of the parking and all, and huge funds will be required to complete those facilities. So can the RP execute the registry on as is where it basis, because LOTs are already living since last 4 to 5 years over there?
Sir,
What would be the solution for that those projects?
I think one has to distinguish between the do's and don'ts and between the powers and the duties of the RP. Whether it is within the complete domain of the RP can say to the NODA authority or to any other authority to give me the CC or OC. Then thereafter he can say whether this amendment is binding on NODA authority or the sub-registrar. Sub-registrar can say you do whatever is there within your domain. But so far as my work is concerned, how I am binding by your IBBI? First of
No,
all,
no,
you
correct.
get because this is a statutory amendment, this is a statutory laws under the Registration Act, under the Stamp Act, and under the Greater Noida Authority. This is a statutory act of Parliament, Parliament, the state legislation. So RP has its own limitation. He can pursue, he can follow up, but he cannot say no. You have to grant it. Because I had an experience. You go to Noida authority and you face the consequences. They say you whatever you may be the RP, but you must understand what is the local laws. First of all, it has to be complied with. Then thereafter, we are obligated to give you. Otherwise, you go to the court, get a directions, and we will do it.
No issue. Correct. So, what is my view is this? RP or any person cannot bind the registrar or the local development authorities that you must give us the OCCC. That will not be there. But let us further define this question. Suppose in a project, certain registry has already been done by the builder. Despite of there was no OCCC, right? And the position was given to many people. Some of them having the registry and some of them are not having the registry and residing on the same tower. In that case, what is your view, sir?
There may be one situation because you know what's happening on now. First of all, it was the project because the insolvency you see it is on the entire project. So irrespective of that, whatever how many towers blocks may be there. Now then thereafter it is confined to the tower or the block. Now again it is coming on the floor because what NODA authority I have seen in many cases, the NODA authority says so far as this floor is concerned and other facilities are there so far as fire and lift and all these things. So we can give a NOC for the floor wise. So this may be what only just I am guessing, only just because the example which you have quoted, it may be relevant to that because the builder, you know, by some friendly association, so he would have get a NOC or CC for the particular floor, wherein maybe the five flats, 10 flats, 12 flats. So for that registry would have been affected. But so far as my experience is concerned, I can say it is never possible to do registry without getting an OC or CC.
Correct. So let us conclude this. It depends on case to case basis. It depends on the project, the stage of completion, the other compliance requirement. On that basis, the RP or the COC can decide whether is it the case for transfer, petition, or the registration.
Yes.
Let us conclude this way.
Yes.
Fine, sir. So now coming to the second amendment, which is Regulation 16C, which has been inserted in this amendment. So now again, I will refer to the discussion paper on this point. So this is the point number 5 of the discussion paper dated 7th November 2024. So what was the issue and why this amendment has come into place? The issue was the current provisions in the IBC and CIRP regulations allow for only one authorized representative per class of creditors, regardless of the class size. In cases where a class has a very large number of creditors, a single AR may face challenges in effectively representing and communicating with all the creditors. This can potentially lead to inadequate representation of diverse interests within the class and communication and representation. So this was the issue. The proposal given was that we propose appointment of facilitators for large classes of creditors, primarily to improve communication and representations. So this was the issue. So to address this issue, the regulation 16C in the CIRP regulation has been inserted. Now we will go through the regulations. So when this regulation will be implemented or will be effective or will be applied, where the number of creditors in a class exceed 1,000, the committee may direct the IRP, RP as the case may be to appoint an insolvency professional other than an IRP or RP and authorized representative or AR also, or any other person as facilitator for a subclass within the creditors in a class, subject to the following conditions. So appointment is subject to conditions. There are certain conditions. So first thing which is very unique in this, that up till only insolvency professional can be, I mean, uh, inducted in this process, maybe IRP, RP, AR, liquidator. But now this regulation says or any other person. So here the facilitators need not to compulsorily be IP. There may be other person than the RP to be appointed as the facilitator. The conditions for the appointment of the facilitators are: A, the appointment of facilitators shall be considered only if, after the first meeting of the committee, a subclass comprising of at least 100 creditors out of the total number of creditors in a class request for the inclusion of an agenda for such appointment along with the name of the present facilitator. So here, suppose in a project, in a class, there are 1,000 home buyers or 1,000 such class of members, and 10%, 100 means 10% of the total numbers request for the inclusion of agenda for such appointment along with the name of the board facilitator. So this is the first condition. Second, the total number of facilitators shall not be exceed. So any number of facilitators can be appointed, but in any case, they will not be exceed 5. Third, the fee of the facilitator for each subclass shall be 20% of the fee specified for the AR, and such fees shall form part of the resolution process cost. Sub-regulation 2 also prescribe that committee may replace the facilitator for the recommendation on the recommendation of the majority of the members of the subclass. So this is somewhat inserted in this CIRP process. So let us discuss what is the need of this inducting the facilitators. Are AR not sufficient in such a project? The view of the members, please.
Sir, before appointment, now we have to understand, and I want to know particularly, I can take a liberty to say like this. See, facilitator कहाँ से आएंगे? सबसे पहले जैसे कि हम AR की बात करते हैं, AR क्या होता है? AR पहले एक IRP अपॉइंट हो गया, उसके 3 दोस्त हैं या 4 दोस्त हैं उसके. मतलब I am telling the bitter truth. Don't take it otherwise, and it's not my intention to anyone. I'm talking about the practicality. You know, then thereafter he will say these are the 4 persons you vote for that, and 4 are all brothers. Okay, so you have to choose one of the brother only. So first of all, I want to know, so how effective AR is that? I am following number of projects wherein RP जो AR वो करता है जो RP कहता है उसका फेवर करना है. अगर होम बायर अपनी कंप्लेंट भी देता है ना AR को, तो वो वहां तक नहीं पहुंचती है तो किस डिस्ट्रिक्ट फैक्ट के साथ में उसका रेस्पॉन्स आता है वो जानता है जो देता है इसको. तो अगेन द सेम थिंग, ये फैसिलिटेटर आएंगे कहाँ से? इसका इंट्रो कहाँ से होगा? जैसे कि AR की मैं बात कर रहा हूँ ना, फैसिलिटेटर को प्रपोज कौन करेगा? सो व्हाट विल बी द क्राइटेरिया? Again, it will be the same person like AR, or who is near or dear or is very, who have a very good compatibility with the RP और IRP, वो आएंगे फैसिलिटेटर इसके अंदर से। और फिर क्या है, CIRP कॉस्ट बढ़नी है उसके अंदर से। फैसिलिटेटर क्या करेगा, जो सेकंड क्वेश्चन इज दैट फैसिलिटेटर की जरूरत क्या पड़ी, मैं उस क्वेश्चन पर बाद में आता हूं। पहले क्वेश्चन पे मैं ये आता हूं कि फैसिलिटेटर का इनफ्लो कहां से होगा, उसके जेनेसिस कहां से होगा, कौन होगा। इंसॉल्वेंसी प्रोफेशनल तो होगा, ठीक है, वो क्या काम करेगा क्या नहीं करेगा, लेकिन वो आएगा कैसे। इसके लिए इन लोगों को अगर करना है IBBI को, तो आप लोगों को एक 6 महीने में लिस्ट निकालते हैं एम्पेनलमेंट्स की। सो व्हाई दे डोंट पिक अप फ्रॉम देयर इवन AR आल्सो, because they will get a, because they will be unrelated, unknown persons, and they will do impartially and particularly for the upliftment or the for the benefit of the home buyers. आप AR को तुम अपॉइंट कर देते हैं, फैसिलिटेटर को भी अपॉइंट कर दोगे, ठीक है। वो तो आज भी मैं AAA का नाम लेके बता रहा हूं आपको, पर्टिकुलरली एक प्रोजेक्ट के अंदर से उसने 15 ऑब्जर्वर्स रखे हुए, मिनट्स में ऑफिशियली आते हैं। मेरी समझ में नहीं आती कि पावर कहां से आई उनके पास में। COC की मिनट्स में उनका नाम आता है, और मैं आपको वो बताऊं वो कौन होते हैं। वो होते हैं जो 15 टावर के 15 प्रेसिडेंट बने हुए होते हैं ना, रिप्रेजेंट करते हैं। उनका फ्लैट जाके देखेंगे, सबसे पहले उनका फ्लैट बनता है। अब वो नेता होते हैं और उस काम को करते हैं, बेचारे जो 90% होम बायर्स होते हैं वो उनके पीछे पड़े रहते हैं। तो आई एम कमिंग फ्रॉम दैट पॉइंट ऑफ व्यू। तो फैसिलिटेटर की जरूरत क्या पड़ गई, फैसिलिटेटर को कितनी नॉलेज है उस प्रोजेक्ट के बारे में, क्या वो जानता है, क्या वो फैसिलिटेट कर सकता है। बिकॉज एंड ऑफ द डे इज दैट कि भाई पैसा है उसके पास में तो कंस्ट्रक्ट कराएगा, दिस इज RP ड्यूटी। RP उसको फॉलो अप करेगा, COC को बताएगा। तो फैसिलिटेटर फर्स्ट ऑफ ऑल आएंगे कहां से, दिस इज टू व्हाट आई वांट टू नो अंडर दिस अमेंडमेंट।
Yes, yes. Yes, any other view of the members on this amendment? See, if you see the discussion paper, what was the issue? Issue was that very small issue was there. There is no communication because the large number of cyber cases are there. They are effectively see this effectively representation. So what they will represent? What is the power of the power duties has been given? Duties has been given. So I don't think there was a very much need of this person, because whatever the role of the AR was there in the CIRP process, the AR attend the COC meeting on behalf of the home buyers. He convene a meeting of the home buyers and take the views and put up the views before the COC. If the voting share is large, then his views are maybe, honored. Otherwise, if the voting is negligible, then the COC is not very much inclined to accept his views also. I've seen the cases. So again, you are right, Mr. Arun, that what is the need of facilitators to introduce, and where this facilitator will come? They will be the same person, like they may be the flat owners in between among the many home buyers and all. So anyhow, so this is the amendment which has come. So other than IP, any person can be facilitators. They shall not be more than 5. Fee will be 20% of the fee of the AR maximum, and the committee may replace the majority. So this is all. Yes, anything we want to discuss on this, because this is very theoretical? No. Now, roles and responsibility. There is no power, in fact. This is the role and responsibility which is given under Regulation 16, Sub-Regulation D of the CIRP regulation. The roles and responsibility of the facilitator include the following. First, facilitate communication between the AR and the creators of subclass. It means the facilitator has come into picture because AR was not representing or communicating with the creators for whom the AR has been appointed. So now facilitators will come and AR will communicate with the facilitators, and facilitator will communicate to the subclass of creators. So now, so there will be, 3 part. First, communication by between the COC and the AR, then AR to facilitator, then facilitator to the particular class. What I can understand from A. Second, attending the meeting of the committee as observer means he cannot write to speech, because observer usually do not speak in the meeting. To facilitate communication between creators of the respective subclass. So he will attend, he will observe and communicate with the subclass, see what has happened and what have not happened in the COC meeting. Second. Third, providing information and clarifications to the creators in a subclass about insolvency resolution process as per advice of the AR. So before communicating to the subclass of creators, he must discuss with the AR that what are the things which he need to discuss with the subclass of creators. This is what about point number C. And D, any other task assigned by the committee to improve representation and communication. So this is the role of the AR in nutshell: communicating or representing or the whatever you can say. So this is some role which is prescribed over here. So any views of the members on this? Yes, Mr.
I think he is directly supporting to the AR.
Correct.
That is the only role.
Yes, yes, yes. To strengthen the communication, because there are
Yeah.
so many home buyers. If we go into the detail, there are so many home buyers, and AR is busy or AR is not so acquainted to discuss with the home buyers on day-to-day basis or whatever it is. If there will be facilitator, they will be discussing with the home buyers particular class, and if the facilitator facing any problem, he can, I mean, take the guidance or he can discuss with the AR. Then AR in turn put up all the things before the COC. So these are the
I think,
channel. This is the flow of the things.
yeah, I think architect and this type of professionals will be
Good
more
suggestion.
suitable for
Good suggestion.
this
Good
thing.
suggestion. The person who can really contribute to the process
Contribute. Yeah.
must be the
That is true.
facilitator. Otherwise, any person वो नेतागिरी करेगा कि और क्या करेगा, जैसा और लोगों ने बोला ना.
That
Yes,
is true.
yes, Mr. Sandeep, you want to add something?
Yeah, anyone I think who can provide the service to the home buyers and guide them, as RP was communicating, see more than 2,000, 3,000 people are there. Single AR may not be able to communicate well. Anybody, we have seen that certain home buyers is having a very well qualified person and they have a communication abilities. So I think anybody can join that. That is what the regulation says.
Let me now come to the
Correct.
information utility regulation.
Any other views, sir, regarding the facilitator and its role? No. Thank you. So shall we take some 5 minutes, 10 minutes break for tea?
Sure.
If it is,
Sure. Yeah.
yeah, yeah.
Thank
Is
you.
any person from ICSI IIT there? Anyone? So let us take some break. Na? We will again join after
Yeah.
10 minutes. Na? So
Sure.
please stay on. Shall we start?
Yes, sir, we can start.
Yes, sir. So this 16 regulation 16D and 16C have been discussed. Now coming to the another amendments. The participation of the competent authority in real estate projects, regulation 14, sub-regulation. Regulation, let us again come to the discussion paper. Yeah. So what was the issue? Why this regulation has been amended and this new regulation has come into effect? The code aims to facilitate timely resolution of the CIRP of the corporate insolvency while maximizing asset value. In real estate insolvencies, allottees constitute a significant stakeholder group as financial creditor. The current regulatory framework allows associations. Oh, I'm sorry, I'm reading the. So this is the relevant. I'm sorry for reading that. Yeah. The CRP process involving the real estate project authority crucial role for currently lack mandatory representation in the committee of creditors. So this is talking about the local authorities. At present, financial creditors are included in the COC, while land authorities generally, being operational creditors, are not. This absence may lead to insufficient consideration of land authorities' perspectives on land-related issues and regulatory requirements, potentially causing delays or complications in implementing resolution plan due to unforeseen challenges. Moreover, valuable input from land authorities that could enhance the viability and feasibility of a resolution plan is often missed, reducing coordination between the insolvency proceedings and land related matters. Given the significance of land assets and associated regulatory compliances in real estate projects, there is a clear need to ensure that land authorities have a formal channel to provide input during the CRP, while maintaining the decision-making authority of the financial creditors. The report of a study constituted also advocated for suitable representation of the land authorities in the committee of creditors. So the entire issue was that the land development authority must also be there in the COC meeting. They must be represented. The benefit of the representation would be the complex issues regarding the land assets and all shall be deliberated on the in the COC meeting, and it would be better for the resolution of the CD. So what proposal was there in the discussion paper? The proposed amendments would mandate the inclusion of competent authorities as invitee to COC meetings in cases involving real estate companies without voting rights. This would be achieved by adding a new sub-regulation. So and so regulation that we will discuss. Attend COC meetings as special invitee without voting rights by providing competent authorities, including the land owning authorities, with the opportunity to offer inputs and raise concerns during the CRP, while preserving the decision-making authority of the COC. The proposed changes address significant issues in the regulatory framework from a stakeholder perspective. The presence of such competent authority in the COC meetings can enhance transparency and build confidence among the home buyers and other stakeholders in the present process, in the resolution process. So this is the amendment. Now we would delve uh, into this regulation 18 sub regulation 4. So it says that where the corporate debtor has any real estate project, so obviously this local authority would be invited where there is any real estate project in the company, in the CD. The committee may direct. It is not mandatory that the committee committee, if feels right, then it may direct the RP to invite the competent authority as defined in clause P of section 2 of the RERA of the Real Estate Regulation Development Act 2016 related to such project. To attend such meetings of the committee may decide without voting rights for providing inputs on matters associated with the development of such project. So let us break this entire sections in what cases, when, and what would be the role of the authority attending the meeting. So we will read from very first line where this CD is having any real estate project. The committee may direct the regional professional to invite the competent authority. Who will be the competent authority? The competent authority will only be the authority as defined in section 2P of the RERA related to such project to attend such meeting of the committee. See, in all the meetings, सारी meetings में नहीं आना है उसको. जिस meeting के लिए COC बोलेगी वहीं पे बुलाना है. So this is what I can understand from this amended regulation. Without voting rights, the authorities shall not have any voting rights, and the authority role would be for providing inputs on matters associated with the development of such project. So for a very limited role, you can say the competent authority or the development authority may be invited by the committee of caterers if the COC wishes the same. So this is the limited. I think this is going to be limited participation of the authority who will attend. Certainly, the competent person who would be authorized by the authority would be joining the or attending the meeting. Secondly, one question arises in this amendment, that why the authority will join the meeting, even though you invite the authority. Why will they? Why they are willing to join the meeting? Will they getting anything from the project? What is your view on this regulation? Members, please. What is your experience?
I think
If you have,
this RERA audit is already there as a part of the real estate projects. So more or less, they check everything in the projects, and then local authorities like DTCP, Country Town and Planning Department, because they are doing the all work, writing approval of the plans and everything. So they may be a part of invitees, but as you said, why they will come, that may be a question. But
yeah,
if they
because
come, then
yes, please.
if they come, then at least the process will be fast, and all other stakeholders will know that we are going in a right direction. That is what I think law also requires.
Yeah, the intent of the law is very good, very genuine. But the $1 million question is why they will join. They are purely, see, the
Very important
authorities.
question.
Yeah. And the person who is joining, IBPI must come with the regulation that there must be some mandatory requirement on the part of the other persons also, other authorities also. Like
See,
if
they are
the
only,
law does
they are
not,
only,
yeah,
yeah. They are
But the
only
problem
looking
is
for
this,
their money. That's all.
correct. So if they are not getting anything from this process, they will not be joining.
They will not be.
This is
Agreed.
my
Yeah.
view on this. So let us see the definition of the competent authority under the RERA. I have given. So
It's
appropriate authority as competent authority. Yeah? So I think the appropriate authority
it
has been
is.
defined under RERA. Sorry, competent authority. I have written the appropriate authority. This is the this is not the right nomenclature. So competent authority means the local authority or any authority created or established under any law for the time being enforced by the appropriate government, which exercises authority over land under its jurisdiction and has power to give permission for development of such immovable property. So if you see the definition of the competent authority, it means the local authority or any other authority created by law. So suppose in a city there is municipal corporation also, there is land development authority also. So I think both will be covered or only the land development authorities will be covered.
There are two type of properties. One is for local area authority, like municipality and all. Another is agricultural land, which is converted by town and country planning department. So both have
Okay.
different rules. So that way, depends on case to case. Competent authority will be. Who will decide?
Okay.
I don't know, but it is like this only.
Okay. So the power to give permission for development of such immovable property. So whosoever has the power over that property or that land is the competent authority. Like
That
if
is
a property is situated in a very, I mean, in a village, then I think Jila Panchayat or the Lag Authority
yeah.
would be the development authority in that case.
Hmm.
If it is in the town, then the Land Development Authority, like I'm in Lucknow, then here LDA is there. In Kanpur, KDA is there, and in Noida, and Noida is there now. So this is the competent authority, I think.
Yeah, that is true.
Yeah. Yeah. So I think this is a very small point of discussions in this. That definitely, if we talk about the positive point, if really the authority is keen to contribute to the CIRP process, then some competent person or the person who is really looking after the project, which is where the CIRP is undergoing, the dealing officer of the particular authority should have been directed or should have been authorized to attend the COC meeting if COC desires, and definitely there must be some set of information which may be relevant in the particular project, which requires the consideration or which requires the information to be taken from the authority, must be prepared beforehand by the RP to get the value of the property or to get the process smoothly driven. This is my small presentation regarding this 18 sub-regulation 4. Now let us move forward to report on the status of development rights and permission on real estate projects. So this was also there in the discussion paper, I think. No. Oh, I think that was not there. So let us discuss this. Where the corporate debtor has any real estate project, the registered professional shall. So this is very important amendments which has been inserted there by regulation 30C. The RP shall prepare a report detailing the status of development rights and permission required for development of such project. Submit the report to the committee of creditors for its comment and submit the report within 60 days to the adjudicating authority. So within 60 days time is there. So in a cases, in companies where there is any real estate project, the RP now mandatorily has to prepare a report on the development rights and all. Reports will be submitted to the COC member, to the COC for their comments, and the report shall also be submitted before the NCLT on or before 60th day of the insolvency commencement date. So I want to understand from the lending members, have there have they been ever been come up with this report? Anyone having the experience of preparation of the report? What are the reports? If someone can share their experience over here. If someone has handled the uh, real estate project, usually let me explain. Usually the committee of creditors wants certain reports on the project which is there, which is under construction or which might be completed, on the development rights and permissions required for development of such projects. Yet the role of the local development authorities is crucial. So usually the development, usually in real estate cases, some agency was usually hired by the RP, and they will assess the buildings, rights, the cost, everything of that project. They prepare the report, what are the shortcomings in there, how much time it would take to complete, and all the complete set of report was requires there. And that report usually prepared and submitted before the COC meeting. But the time limit of 60 days or filing before the NCLT is very less, I think, because see, the first month of the CRP usually passed in the preparation of the claims and holding the first meeting of the COC and all. Then next 60 days, it requires the challenge is getting the information. In every cases, RP may not get the proper information to get the report prepared. Even the agency which is hired or which have been hired for preparation of this report, they also take the time. So 60 days is may not be the sufficient time, although in some cases this may be sufficient time. So, but anyhow, we have to comply with this. As a RP, we need to prepare the reports on development rights and permission required for development of the project, and this need to be discussed before the COC. Regulation 30C. Now coming to the other regulation, amendments in regulation 31, insolvency resolution process cost. So this is the effect, basically given effect to the cost of the facilitator. The whatever cost of the facilitator shall form part of the insolvency resolution process cost. Regulation 31 sub-regulation AC has been inserted, which says that, lays down that fee payable to the facilitator under clause C of sub-regulation 1 of regulation 16C shall be the insolvency resolution process cost. So this is what regulation 31 AC. Now coming to the other amendment, relaxation for real estate allottees, amendment in regulation 36A, invitation for expiration of interest. So relaxation, now I'm coming to the discussion paper. See, this point number 3 of the discussion paper. What was the issue? Actually, the code aims to facilitate, I've read this. Now coming to the operating part. The current regulatory framework allows associations of allottees to participate in the CIRP as a resolution applicants. So this amendment has come from, to settle the issues. While these requirements are designed to ensure serious participation, they may inadvertently exclude genuine stakeholder group like LOT associations from the resolution process, particularly in real estate insolvencies LOTs where have the most direct interest in the project completion. However, as highlighted by the report of the study group, there are some ambiguities regarding powers of the COC to relax eligibility criteria, earnest money deposit requirements, and performance security obligations in case of these associations. So, to settle the issue, some proposal was devised. The proposal was to address these challenges. It is proposed to clarify by way of explanation that the committee of creditors is empowered with the discretion to relax certain conditions for qualified associations or group of allottees to participate as resolution applicants in the CRP. The proposal aims to amend the CRP regulations expressively, provided that the COC may approve relaxation to the eligibility criteria, earnest money deposit, and performance security requirement for allottee association of group to represent at least 10% of the allottees, 100 allottees, whichever is higher. So this was the proposal given. Now the amendments has finally come by way of some clause. The clause is clause E. After clause D in the regulation 36A. So what regulation 36A says? 36A is the section which prescribes the conditions for expression of interest or provisions for expression of interest. Clause E, which has been inserted, that provide the details of the corporate debtors registration as MSME and so and so. After clause E, the following proviso shall also be inserted. So this is the proviso which is inserted here. Provided that where the CD has any real estate project, the committee for an association or group of allottees in such real estate project representing not less than 10% or 100 creditors out of the total number of creditors in class, whichever is lower. You can see that in the proposal, the word was whichever is higher. See, in the proposal, whichever is higher. But actually, the amendment has come that either 100 number of persons, number of allottees, or 10%, whichever is lower. They can the criteria in respect of eligibility and refundable deposit. In these two conditions, the relaxation may be given by the committee of creditors. I am again reading the inserted proviso. This one. Provide that where the CD as an representative, the committee for an association or group of allottees. This is for limited RA. The RA shall be the association or group of allottee in such relationship. This is not for other association. This is the association for that particular project, to my understanding. Representing not less than 10% or 100 creditors out of the total number of creditors in such class. So in that particular project, the number of allottees may be 100 or 10% of the creditors of such class, whichever is lower. The relaxation in respect of eligibility criteria, which the COC will prescribe in this case, and regarding the conditions for depositing of the refundable deposit or So in these two conditions only, the relaxation may be granted by the COC in this case. So the power has been given to the COC. I think this is very much clear. So why this amendment has really come into picture? Because you see now there are some projects. Let me give you an example. That is a project where almost the entire things have constructed. The project is constructed, completed, or there may be project which has not started or whatever stage it is there. The particular association of that project, there may be association, they may be fighting with the builders for their rights to get, and the company goes into the liquidation, and that group of allottees or the association wants to participate in the resolution process. Since they are not the people like who can meet the eligibility criteria, because they are not the business entity, they may not having the net worth, they are not having so much of resources to deposit the refundable security, but they have the capacity, how they can get the allottees gather, they can contribute for construction or for development or for completion of that project, and they are very sure because the particular allottee who are associated with the project which undergo insolvency, no person other than that set of people or that group of people having the more interest than other. So this is a very welcome, to my mind, this is a very welcome amendment which has come into play, come into picture. So this will go a long way, I think, because the associations or the allottees who are there, who wanted to get their project, and they will be, I mean, where the project by insolvency is there, they would be the RA, and their proposal would be, I mean, much beneficial for the benefits of the home buyers. So any other viewpoint on this by the learned members? Okay, now coming to the another point. Relaxation for real estate allottees, Amendment 36B, request for RFRP. So, see that the relaxation was for the submission of the EOI. So, let us understand what Regulation 36A and Regulation 36B are. So, Regulation 36A for the invitation of expression of interest. This is the stage where the RP invite expression of interest. Here, the relaxation has been given to this association or group of allottees in terms of eligibility criteria and refundable deposits. And under Regulation 36B, where they have to submit the resolution plan, RFRP. Under the RFRP, the relaxation has been given in terms of the performance guarantee and all, I think. Na? So I am reading this. The following proviso inserted. Proviso implementation schedule. To provide that where the corporate director has any registered project, the committee may relax the requirement of providing performance security for an association or group association in such real estate project, representing not less than 10% or 100. So this is for the deposit of the performance security. So COC may relax the requirement for deposit of the performance security in case the RA is group of allottees or the association. So this is very simple. Now coming to the amendment in Regulation 38, subsection 4 and 5. So this is the Regulation 38. Yeah. So before this 4 and 5, before the amendment, the Regulation 4 and 5 are I have placed here. The committee before substitution, this was the provision. The committee may consider the requirement of monitoring committee for implementation of the resolution plan. For the 5 subsection 5 of the Regulation 38, where the committee considered that monitoring committee for the implementation of the resolution plan is required it may, while approving the resolution plan, decide to constitute the same with the resolution professional or propose another insolvency professional or any other person of its member. So these 4 and 5 now substituted with the 5 only. So this is the amended regulation, regulation 4. What this regulation says, so before going into this, let us understand this is the mandatory content of the resolution plan. So under the resolution plan, the RA has to mandatorily give the provision for this implementation of the resolution plan. So what regulation 4 says, the committee shall consider setting up a monitoring committee for monitoring and supervising the implementation of the resolution plan. The monitoring committee may now the committee shall consider setting. Earlier, before this amendment, there was a discretion on the committee, because the committee may. Now the committee shall consider setting of the monitoring committee. Monitoring committee for monitoring and supervising of the plan and implementation of the resolution plan is mandatory now. The committee shall consider the setting of the committee, and the monitoring committee may consist of the RP or any other insolvency professional or any other person, including representatives of the committee and representative of the resolution applicant as its member. So these are the persons who may be member of the committee, monitoring committee. Provided that where the resolution professional is proposed to be part of the monitoring committee, the monthly fee payable to him shall not exceed the monthly fee received by him during this insolvency resolution program. See, IBPI always see whether resolution professional is not getting what he is getting during the CIRP process as a fee of the RP. So here IBPI has given and imposed a cap on the monthly fees of the IP. So he cannot be remunerated by more than what he is getting as a RP on monthly basis. The monitoring committee shall submit quarterly report to the adjudicating authority regarding the status of the implementation of the resolution plan. So I would request the participants to share their views on the implementation of the resolution plan in the real estate matters, because I'm hearing that in most of the cases where the resolution plan have been approved, there is some challenges in implementation. So any of the learned members are is facing such issue in their CRP after approval of the plan? Is there any problem in implementation? Why the role of the monitoring committee important and all? Any member can share their view. Fine. So let me share my views here on this amendment. See, after approval of the plan, the monitoring committee is empowered to see the implementation of the resolution plan. In the real estate matters, the approval and permission usually comes from through the authority, or you can say the local authority, development authority. And development authority, until it is not sure whether the requirements and compliance is complete or not, it does not give the permission to construct the building or whatever pendency is there. So the role of the monitoring committee is very important. In many cases, the monitoring committee is there. The RAs following with the development authorities for getting the permission so that the plan may be implemented. But actually the plan is not getting implemented because of the approvals are not being granted by the development authorities. So in such cases, what can be done? What will be done? There are I cannot name the case, but I'm aware that in a case where the resolution plan was approved 1 year back from now, and the RA is willing to comply with all the requirements, but the authority is not giving the approval. So the plan is not getting implemented. In some cases, there is 2 to 3 years also. So this implementation is very challenging. That is why the IBBI has come up with this regulation, amended regulation, that committee shall consider setting up the monitoring committee for implementing and supervising. Because supervisory role is also important. The monitoring committee shall submit the quarterly report to the NCLT. If there is any problem in implementation, or if there is any problem in getting the approval, the same may be come into the knowledge of the honorable NCLT. May the directions from the NCLT may be short and all. So this is what the resolution. This is what the resolution plan implementation uh, can be achieved by the effective uh, supervision by the monitoring committee. Now coming to the another amendment, this I have taken. So this is brief about the certain amendment which has come into it. Any questions on this or any discussion about this? Although we have discussed everything, yeah. I have discussed the entire amendments which have been there on 3rd of February. So anything we want to discuss on this amendment? If not, then we can move forward. No. So one thing, one amendment, one circular has recently come. I want to discuss that circular. Please give me 2 minutes to get the circular. I'm stop sharing this for now. Yeah, this is the circular I want to discuss. This is very recent circular on 11th of February. I wish to read the circular before intimation to the board on appointment of insolvency professional under various process under the code. So as you all know that whenever we take any assignment, we have to intimate to the board the assignment which we are going to take or which we have taken. So this circular says that an insolvency professional IP functions in various capacities under the Insolvency and Bankruptcy Code. The IPs are mandated to intimate the IBBI of her appointment under various processes under the code. Presently, IPs add their assignments on the IBBI portal for appointments as IRP, RP under the CIRP process, as well as the liquidation in liquidation and voluntary liquidation processes. Upon assignment approval, subsequent reporting requirements such as public announcements, EOIs, auction notices, and various forms are made available for submission to the board. Further, presently there is no requirement for adding assignments. This is important. Please note, as all of you know that resolution professional under the insolvency resolution of personal guarantors, bankruptcy trustee under the bankruptcy process, and personal guarantors and administrators under insolvency and liquidation proceedings of the financial service providers. So in these cases, the add assignment was not required. Now IBBI requires that, I am reading this, to streamline this process and ensure thorough record keeping, the board has defined the assignment module. While most IPs already update their assignments upon appointment, this directive formalizes the practice to reduce compliance burden and minimize delay. The IP henceforth mandated, now it is mandatory, to add the assignments on the IBBI's electronic portal upon their appointment in the following process and capacities. So, appointment as IRP, we have to add the assignments. As RP, under the CIRP, we also add the assignment. As liquidator, when we appoint or when we get any case, we add the liquidator. Under voluntary liquidation, we also have to add the assignment. This resolution professional under insolvency resolution for corporate guarantors. Here there was no tab as of now. So now the IBBI has mandated this. If you are getting any assignment, you have to add, you have to intimate the IBBI to the electronic portal. Another, bankruptcy trustee under the bankruptcy process for personal guarantors. If you are getting anything, you have to report. Administrator under the insolvency and liquidation proceedings of the financial service provider. Here you have also. Timeline has also been prescribed. Let us also go through the timeline. An IP cell access the portal with the help of unique username and password. You all know. You have to get the login to the portal. Once the assignment is added and approved by the IBBI, the IP shall proceed with the subsequent compliances, including reporting requirements such as public announcements, EOIs, and auction notices. The applicable under various provisions or processes. The timeline. Now let us come to the timeline. What the timelines have been prescribed. So everyone need to do that. For any new assignment, for all cases, whatever prescribed over there, herein above, all cases commencing from the date of issuance of the circular, that is from 11th of February, the IP shall add the assignment to the designated system within 3 days. So this is already there. We have to report to the IBBI within 3 days of my appointment, of our appointment. Second, for ongoing cases, for all ongoing cases initiated before the issuance of this circular, where the assignment has not already been added, the IP shall add the assignment by 28th February 2025. इस महीने आपको अपना असाइनमेंट ऐड कर लेना है अगर अभी तक नहीं किया है। तो कुछ केसेस में जहां हम लोग अपॉइंटेड हैं ऑलरेडी, जैसे पर्सनल इंसॉल्वेंसी का हो गया, वहां पे अपॉइंटमेंट है, तो उस केसेस में हम लोगों को करना है। थर्ड, क्लोज्ड केसेस, द केसेस विच हैव बीन क्लोज्ड। सो दिस इज अ वेरी टफ टास्क फॉर ऑल ऑफ अस। फॉर ऑल क्लोज्ड केसेस वेयर द असाइनमेंट हैज नॉट already been added, the IP shall add the assignment by 31st of March. 2025. However, for closed cases relating to personal guarantors, the assignment shall be added by 30th April 2025. So this February and March is again going to be a month of compliance for all of us. So we have to comply this also. So this I wanted to, I mean, let you know. So this is all. Now, if we want to discuss anything in this amendment and all, we can discuss. Yes, please. Mr. Prabhu, you want to ask, you want to say something?
No, I want to ask one question. There is a two type of purchase in during the liquidation. Sale as a going concern. So a lot of people are asking whether income tax benefit of 8 years or losses for the carry forward will be available or not. So I've checked with various people, but nobody has got clear concept what will happen. Rather, advocates, senior advocates, they say, "Yaar, why you are going for sale as a going concern? Go for a resolution plan company. That is a better solution." So, what is your suggestion?
Okay. I will let you know to my understanding. So let us also understand from other learned members here what is their views on this. So you are talking about the sale of CD as a going concern liquidation process, right?
Yeah.
Yeah. So any learned member who have done this, because I think many people are here. Senior persons are also there. Let us benefit from their expertise.
Yeah.
No.
You have also handled, I think, a lot many
Yeah,
liquidations.
I will share my understanding, but since there are some questions which are still unanswered.
Yeah, that is the query.
So, see, to my understanding, let me share that if we sell the CD as a going concern under the liquidation, the uh, the CD is not dissolved in that case
Yeah,
because
it's
it's
continuing.
huh?
Continuing.
It's continuing. So this is the other form of the resolution plan, the resolution of the
Yeah,
CD.
certainly.
The resolution process has failed, but still there were. So I've seen one case where the CD has been sold as a going concern, and I have I spoke to the liquidator, and I've discussed it also in. So I think the benefit of the accumulated losses you are asking for, right? So
Yeah.
it was there. It was there. It was allowed.
So you meant to say that A has to give a order. We
A
have to
has to
apply
give,
and
certainly. A has to give the order because if you sell the series a going concern, this sale has to be confirmed by the A
yeah,
application.
certainly.
And in the application, the relief would be asked.
So relief and concession has to be
Yes,
applied by
has to be
the successful bidder.
correct. So relief and the application would be filed before the A, and whatever reliefs and concession you are asking, just like in the resolution process,
Yeah,
you are asking here, and if the A allowed, you
yeah.
will be getting the benefits, whether it's accumulated losses or whatever it is.
Okay.
So this is my view, and I can I'm very well aware that this has happened. I don't know. I have to refer the order whether it is there or not. But for this purpose, the company was taken as
Yeah.
as a going concern under the liquidation process.
Because I feel that instead of waiting for long in resolution plan, you purchase company as a going concern and do it. It is very good. Good way of acquiring. We have recently acquired a company in
Yes, yes.
Mumbai, so that way we are working on some few more companies
Okay, so you acquired the company as a going concern
as
in liquidation
as
process.
a going concern.
So, you know, getting the order of liquidation is also a tough task from the A.
But once it comes, within 15 days, you take over the company because sales certificate can be issued immediately.
Immediately.
So part of the thing has come, and then you
Mm.
apply for this relief and concessions. So order comes in 2-3 months or that's
Without
it.
much challenge. Without much.
Without much
Yeah,
challenge.
yeah.
Better way
That's
of
it.
working.
I think people are going into this also.
Yeah.
This can happen, I think. This is allowed. Yeah. Any other experience you can share, sir?
You
Some good
tell us, sir,
questions.
you have done
Because we have
lot
ample
many
time. We have ample time.
ample time. Yeah, I know.
Because no,
You
the amendments are not so much an amendment to cover in 3 hours of session. But
nowadays, few companies are coming in CIRP. More or less all the
yes, yes. So
settlements are done.
actually, this the cases are very much going. I mean, reduced day by day, and
Day by
I think
day.
everybody is worried. But I think some NP is inching up nowadays. So although I cannot wish that there must be NP and we are getting the assignment. I cannot wish like
Understand.
this. But if there is so, then the cases will be done. And IBBI may also think for the personal insolvency for individuals also.
Now banks are now more flexible on OTS. They are
Okay.
looking forward for settlements rather than going for CIRP
Yeah,
because
yeah.
they feel that they don't get the right dues in CIRP,
Hmm.
whereas in OTS they get a better value.
Hmm. How this PIRP is working? Pre-pack insolvency?
Pre-pack is not working, I think. There are only few reported cases, but
Hmm.
nothing is happening because banks are not very willing to go for PIRP. They
Correct.
say that either OTS or CIRP, this is the only solution.
So how it can be? I mean, this has been come and there was much, I mean, noise about this that more of the cases will be come through PRP, but it's not taking shape. I don't know
The
why.
banks, bank board, if they give a proper policy on this, then it can be a very game-changing scenario because the purpose is clearly defined. Only
Hmm.
that banks have no policy on it at present, and no
Yes.
authority to the lower people like Jones or GMs. They don't have any authority.
Hmm.
Ultimately, everybody has to go to headquarter,
Hmm.
and
Hmm.
decision is delayed, so nothing is happening.
Yeah, and the OTS is also very flexible right now nowadays.
Yeah, OTS is flexible. Government is also pushing OTS,
Hmm. Hmm, hmm,
and
hmm.
nowadays market is booming, so they get good price of real estate.
Correct.
So
Correct.
everybody is looking for that.
Correct. Right. So let us wind up this now. So thank
Yeah,
you.
yeah, sure.
Uh,
Thank you very much.
Anyone from ICSI is there who can?
We all are from same.
No, no,
they are
from the
they are wai- they are waiting for 5:30.
that is right, but no, because in the amendment we have nothing left. We have
Everything
covered
is completed.
the entire thing.
No, it's wonderful. You have very well spoken about
So
everything, and
I
it's a good
I tried
knowledge sharing.
to. I mean, I tried to not like a presentation. I tried to be a deliberation because we all are having so much of problems in the real
Yeah, yeah,
estate, and there's so much confusions, and the learned participants who have participate in this discussion, they enhance the knowledge of every one of us because we
yeah.
are, although we are expert, but we are not expert. Now,
We are not expert.
this is the area where we are learning each and every day.
Every day. Yes,
Yeah,
yes.
yeah,
That
this
is
is the
true.
problem. Yeah. So let me communicate them that
Yeah,
now
we
at the
can
verge
close
of
it.
ending of this session.
Yeah.
Yeah.
Hello, sir.
Now we have taken the, I mean, all the amendments and all. Now, if you allow, we can close this session now.
Close.
Yes, sir, please.
Yeah,
Thank you, sir. Thank you for your valuable time and giving your learnings. It
yeah.
was a wonderful session.
Thank you, sir. Thank you,
Thank you very
everyone.
much. Thank you,
Namaskar.
sir. Thank you very much.
Yeah, yeah.
Thank you.